Eugenia Cooney is now involved in a lawsuit. Now, if you don't know, Eugenia Cooney has been offline for quite a few weeks at this point, which is extremely unusual for her. She tends to be online non-stop. Usually these days on TikTok, she'll be posting or she'll be doing lives and stuff very often. But she has been radio silent. Now, the last time we spoke about her was when people were suggesting that she was no longer with us, even though there was no evidence to that fact. And of course, people were still speculating now with her disappearance that maybe she was gone, maybe she was ill, maybe she was recovering, maybe something else happened, maybe she got banned from TikTok altogether. So many different questions were raised, and even people like Jeffree Star had to step in and say, hey, yeah, she's grand. Stop now. Like, when Jeffree Star is the one telling you to calm down, things have gone too far. But now we might have some insight into why she's gone, where she's gone, what's going on, and that is to do with this lawsuit. Now, it's very important for me to say this is alleged that this lawsuit is connected to her disappearance from TikTok and from online spaces in general. This does not necessarily confirm that that's why she's gone, but regardless of whether this is the reason for this or not, it's very interesting what's being said in these legal documents and the reasons why they are naming Eugenia specifically in a lawsuit that is meant to be targeting TikTok and other social media platforms. Now, this is all to do with an ongoing lawsuit that began in 2022, but as ongoing suggests, it's still going on. That's what the word means. I don't know why I felt like I needed to explain that to you, but I did. So there's new things going on every day, new filings, and the most recent of those name Eugenia. Now, this lawsuit, just to summarize it in the smallest way possible, because again, it's very complicated. It's been going on for 2+ years. 2022 was 3 years ago. Not 2 years ago. Nearly 4 years ago. Anyway, moving on. Basically what this boils down to at its simplest form is that people are alleging that TikTok and other social media sites are harmful for children and their mental health, and potentially even actively engaging in damaging these children's mental health. Now, the reason that we know Eugenia has now been brought into this is that this was posted on Reddit, and I believe this was Vera the Chicken, who was the first person to bring up that she has been named in this lawsuit, and that's what's been shared around on Reddit. So there are some legal documents, and there's also some legal articles. These are basically just news articles, but for people involved with law. From what I could tell, people couldn't read these articles because in order to sign into the website and actually access the website, you had to have an email address that was paid, so like an email address connected to a website, a domain. I have my own website, so I was able to log in and read these. So we're going to read these first, and then I want to go over a little bit of the legal documents. Obviously, we're not going to go over every single document that has happened since this lawsuit was first filed, because why would we do that? We'd be here all day. You don't need it, right? We're just going to focus on what they're saying about Eugenia, what they're saying about TikTok's involvement with Eugenia, and what they're asking for. For that, I'm going to have a sip of kombucha because my mouth is really dry from talking so fast. So here we have the first of 2 different articles that we're going to be reading very briefly about these legal cases. So, TikTok accused of withholding docs on an influencer. Personal injury plaintiffs have told California magistrate judge presiding over discovery in multi-district litigation that TikTok is refusing to hand over more information about the app's relationship with Eugenia Cooney, who is a TikTok influencer with anorexia and 2.8 million followers, according to a document unsealed on Monday. TikTok is balking at requests to produce additional documents about its relationship with Cooney, who collapsed during a live stream in May and had recently visited the social media app's New York office, according to the document. In TikTok's words, Cooney is a controversial influencer who is widely known in the eating disorder community for having anorexia, but despite this, TikTok still brought her into its inner circle and promoted her at brand events, according to the document. I do have a lot to say about this, but I'm just going to hold off for a second and quickly read this article so we can get to the next one, because the next one is newer. This is just background information for what was going on before that when they were withholding the document, so I will comment on this in a second. Meanwhile, TikTok's trust and safety team was unaware that TikTok had hired Miss Cooney as a paid influencer, the plaintiff said in the document. When trust and safety employees learned about the relationship, the team voiced shocked. Wow, her being managed by us. So they're claiming that TikTok is hiring Eugenia as paid influencer, but the trust and safety team at TikTok had absolutely no idea that this was going on, which is concerning, to say the least. The additional discovery would include communications about TikTok's relationship with Cooney and user concerns about her, according to the joint letter initially filed on August 12th. TikTok's relationship with Ms. Cooney was also a central topic during employee Victoria McCullough's deposition in February 2025, the plaintiff said in the brief. The dispute arises from personal injury litigation launched in 2022 against social media companies Snap, Meta, TikTok, and YouTube. The case has been consolidated in an MDL that involves hundreds of claims by parents of minors, school districts, and dozens of states that allege the defendants' platforms, which bring in billions of dollars each year in ad revenues, are designed to be addictive to the detriment of young people's mental health and livelihood. Again, I'll comment on this in a second. TikTok contends that the request is too late, coming after almost 2 months after the fact discovery closed, according to the document. Now, this part I will comment on just to give you some idea what they're talking about here if you're unaware. So in any kind of lawsuit, there usually is a discovery phase at the beginning, which is when all the relevant documents are asked for. So person A is suing person B and says, you have this information about this thing I'm suing you for. Give me the documents. They hand over the documents and vice versa, and that's all the documents and discovery. They're discovering the documents. Easy way to think about it. Now, after the fact, they are asking for more documents from TikTok, specifically revolving around Eugenia Cooney. But TikTok's argument is that discovery is closed, so feck off because we already finished this. Why are you asking for more documents? You should have asked it at the time. Fact discovery must end. Plaintiffs were aware of Ms. Cooney long before the fact discovery period closed and concede that they have already received detailed documents and deposition discovery regarding Ms. Cooney, in addition to information concerning other content creators they explicitly identified in prior document requests, TikTok said. So they already have documents about Eugenia, now they're just asking for more. The discovery request also comes mere months before trial, TikTok said. And Cooney has visited TikTok before, such as in 2024, but the plaintiffs didn't ask for those materials at the time, the social media company said. But the plaintiffs said they asked for these documents on May 29th, the day that they learned of Cooney's collapse and visit to TikTok's office, according to the document. TikTok didn't respond for more than a month, after which the plaintiffs said they sent another letter on July 8th and renewed their request later that month, according to the document. As such, defendants' refusal to visit the issue has resulted in this delay, the plaintiff said. Ultimately, plaintiffs' requests to supplement are reasonable, narrow, and practical. Representatives for TikTok didn't immediately respond to requests for comment on Tuesday. So that's the first one. I wanted to read it very quickly just to get through all of that, and now we will move on to the second one, which has some repeating information, but it's more of a follow-up on this first article. TikTok must produce docs on anorexic influencer. A California federal judge on Monday ordered TikTok to produce documents related to Eugenia Cooney, an influencer with anorexia and 2.8 million followers, in litigation over claims social media hurts youth mental health, and also instructed YouTube to yield documents on 2 of its witnesses. U.S. District Judge Peter Kang told TikTok to look for and produce any documents about Cooney's May visits to its New York offices and her collapse during a live stream. Okay, so let's just break down a little bit of what they're talking about here. So first of all, the collapse that they're referring to, I wouldn't necessarily call it a collapse. I don't think she collapsed. That makes it sound like she fainted, but like these are legal people, so I guess they're using the terms they deem correct. But this is to do with a video that was going around of Eugenia, and I'm not going to show it because it is quite triggering for people, where she seemed to be visibly unwell on stream. She was kind of moving weirdly, and she ended the stream abruptly and just said she didn't feel well. And some people were speculating, as people like to do with Eugenia, that she'd had a heart attack or some kind of seizure or an episode. Other people were saying it just looked like she was going to vomit. So this is what they're referring to here. As for the May visit to its New York offices, what I believe they're referring to here is actually something that Eugenia documented herself on TikTok. Because I remember seeing back in May a video on her TikTok of her going to the TikTok offices, and I kind of thought, it's a bit weird. I didn't think they would want to publicly associate with somebody so controversial. You know what I mean? Because at the end of the day, these are businesses. They usually just want to deal with creators who are neat and tidy and squeaky clean and have no controversy around them. And the second you have any, they will drop you. So I thought it was weird. I'll show you the video now. So this is the video I'm talking about. I obviously can't play the audio because it's copyrighted, but she posted this on the 24th of May. So this was, I believe, the day after that incident with the live stream. It says, "A magical day at the TikTok NYC office. Thank you so much, TikTok, for having me. I'm so incredibly grateful for this experience and everyone who made it so special. Hashtag TikTok, hashtag NYC, hashtag New York City." So you can see it's just her showing bits of the office. There's no voiceover or anything over this. It's just music. So she doesn't talk about like what she did there, what was going on, but you can see that she was there, and I don't know, I'm sure somebody's lip read that part there. I have no interest in doing that, and I do have to continue talking over this even though I have run out of things to say about it, because because I can't play the audio, and otherwise we'll just both be here staring at a silent video, and that would be really weird. There we go, it's over. Great. So again, US District Judge Peter Kang told TikTok to look for and produce any documents about Cooney's May visit to its New York offices and her collapse during a live stream. It's plausible that TikTok investigated whether the live stream was problematic or if it had an effect on young user safety, the judge said. There was media coverage of her collapse, so TikTok might have received media requests or possibly government inquiries about the event, the judge said. And TikTok might have sent communications to staff and outside vendors, like a public relations firm, about how and if to discuss Cooney's fainting episode. So basically, they want to know every communication that they had about this. Were they talking to PR firms? Were they talking to governments? Were they talking to anybody about Eugenia Cooney? Were they just talking to themselves? Was anything said? Tell them. Additionally, it is unknown, but at least conceivable, that TikTok may have received user complaints in response to Cooney's TikTok livestream in May 2025 with regards to an adverse effect on youth users' safety, the judge said. So basically, that people might have been complaining about this, and I'm so sure that they were. Eugenia is constantly getting reports on her accounts and stuff, so I would be shocked if there wasn't a single one about this, because everybody was talking about it. TikTok had balked at the discovery request for information about Cooney. The plaintiff said that in the social media company's words, Cooney is a controversial influencer who is widely known in the eating community for having nervosa. TikTok still brought her into its inner circle and promoted her at branded events, the plaintiffs contended. So, in TikTok's own words, according to this article, they have said themselves that Eugenia Cooney is a controversial influencer who is known for having an eating disorder. But they still brought her into their inner circle and promoted her at events, which is confusing, and I assume why the judge went, okay, no, let's look into this a little bit. The discovery dispute arises from personal injury litigation launched in 2022 against social media companies Snap, Meta, TikTok, and YouTube. The case has been consolidated in an MDL that involves hundreds of claims by parents of minors, school districts, and dozens of states that allege that the defendants' platforms, which bring in billions of dollars each year in ad revenues, are designed to be addictive to the detriment of young people's mental health and livelihood. I mean, I think we all know social media is addictive. I can't say that they purposefully make them addictive, even though I believe that, but I'm not sure if whether I say that would be counted as some kind of defamation. So I'm not saying that they definitely are making them addictive on purpose, but I do personally believe that. Just my opinion. In a separate order on Monday, Judge Kang told TikTok and YouTube to produce documents concerning 2 witnesses. One, Samantha Kersel, was TikTok's witness for certain topics in suits brought by school districts, according to the order. YouTube witness Tom Saffel was deposed on age verification topics. There wasn't any serious dispute about whether some relevant documents are in the witnesses' custodial files, but whether the plaintiff's request for full search was merited, according to the order. In order to have a fair opportunity to cross-examine these witnesses, the scope of their documents to be searched and produced should be more appropriately limited to the scope of the topics which define the scope of their testimony, the judge said. Please, Judge, I beg you, say scope one more time. Basically, they're just saying, in order for this to, be as clear-cut as it needs to be, the only documents that should be produced need to be relevant. That's what I'm understanding here. Judge Kang exhorted the parties, I was going to say extorted, he did not extort anybody. He exhorted the parties to work together on the document search terms and production logistics. The court has repeatedly admonished throughout this MDL that wise and experienced counsel know how to work through and reach reasonable compromises on document production issues, and the court continues to hold counsel here to those same standards, the judge said. Plaintiffs look forward to receiving the documents that TikTok and YouTube have been ordered to produce, along with the additional materials about TikTok's relationship with influencer Eugenia Cooney, Michael M. Wynkiewicz of Lincoln, Cedron, and Berman, LLP, that was so many names I've never read before, an attorney for the plaintiffs told Law 360 on Monday. Transparency is key. TikTok and other social media companies should not be allowed to hide the ball at trial. The public deserves to know how these platforms promote influencers whose content may harm vulnerable young people and what steps, if any, they took to protect their users. Representatives for YouTube and TikTok didn't respond to requests for comment on Monday. And then it says who the representatives are in this, which we don't need to read. So that is the article that is about what's going on in this legal case at the moment. It's quite a lot. It is quite a lot. Basically, in this whole mess of a thing, they're now bringing in Eugenia and saying that she is relevant to understanding how TikTok safeguards young people's mental health. Because if it is clear, or this is what I'm understanding, right? What they want to try and argue is that TikTok knows that Eugenia is harming people, or that her presence is controversial and that she's well known in online spaces that are highly negative and detrimental to people's health. However, despite knowing this, they still continue to promote her. That is the argument they're trying to make. And if they can make that argument, then they can claim that, therefore, TikTok is complicit in harming young people's mental health. This is all insane, honestly, but once you get to the legal documents, it gets even more insane. So there's 2 versions of this document: the joint letter brief on plaintiff's motion to compel written discovery documents and depositions regarding creator Eugenia Cooney. Now, I'm going to read just one of those because this version is just a corrected version of this. So it's the most recent version. I don't see the point in reading the old one and then reading the corrected one. So let's just read the most recent one, corrected joint letter. And unfortunately, I need my glasses. Dear Magistrate Judge Kang, pursuant to the court's standing order for discovery in civil cases, plaintiffs and the TikTok defendants respectfully submit this joint letter brief regarding the outstanding dispute over whether plaintiffs are entitled to additional written discovery, document productions, and a deposition regarding creator Eugenia Cooney. Pursuant to the Discovery Standing Order and Civil Locale Rule 371, the parties attest that they met and conferred by video conference, email, and correspondence before filing this brief. Blah, 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 blah. Not relevant information, but basically this was dated on August 13, 2025. So here is the plaintiff's position. These are the people who are asking for these documents on TikTok and Eugenia Cooney. TikTok refuses to supplement its discovery responses and produce documents and communications discussing 1. TikTok's relationship with Eugenia Cooney, a TikTok creator suffering from anorexia whose TikTok redacted, and 2. User concerns TikTok received about Ms. Cooney. These documents would complete, correct, and update TikTok's existing discovery responses. To date, TikTok has produced over 300 documents referencing Ms. Cooney, its relationship with her, user complaints about her, and related harm to users with eating disorders. 300 documents. TikTok have already handed over, I need you to put this in your brain, TikTok have already handed over 300 documents relating to Eugenia and concerns about her and how she may be harmful to users. 300. That is insane. TikTok's relationship with Ms. Cooney was also a central topic during redacted deposition in February 2025, but from the article we already know who they're talking about, presumably. After that deposition, plaintiffs learned that Ms. Cooney collapsed during a live stream on May 23, 2025, the one we spoke about, and had recently visited TikTok's New York office. In light of this new information, plaintiffs asked TikTok to supplement its discovery responses. TikTok refuses to do so. Accordingly, the court should order TikTok to supplement its discovery responses and allow plaintiffs to take an additional deposition. So they're saying there was new information. Because of this new information, we wanted these documents relating to this and we want to depose Eugenia, as in we want to question Eugenia herself. So here's the background. Images of Ms. Cooney below. In TikTok's own words, Ms. Cooney is a redacted, but I'm going to go ahead and assume, although this may not be correct, that this redacted information is the information that was in the article, that she is a controversial figure who is well known in the ED spaces, according to TikTok. Might say something else, but that's what I'm assuming. Ms. Cooney routinely posts on TikTok and has 2.8 million followers. Even though Ms. Cooney is suffering from an obvious serious eating disorder, TikTok brought her into its inner circle, blank at branded events including TikTok's live programming and TikTok's live battles entitled Road to Superstar. So even though they have branded her themselves as controversial, they are bringing her into their circle, stuff at branded events, and bringing her into live battles and stuff like that. Meanwhile, TikTok's trust and safety team was unaware, redacted, even though we just read that in the article. Basically, they're unaware that TikTok was hiring Eugenia as a paid influencer, according to them. Then there is a huge redacted section that we can't even guess what this is about because it just has one line that's not redacted. So we'll move on from that. A few months after Blank's deposition, plaintiffs learned that Ms. Cooney collapsed while live streaming on TikTok. Ms. Cooney also visited TikTok's offices in New York, as seen in her TikTok posted on May 24th, 2025. Plaintiffs promptly asked TikTok to supplement its discovery responses limited to specific documents concerning Ms. Cooney. TikTok has refused. Specifically, plaintiffs request TikTok supplement the following information: new documents / communications discussing TikTok's relationship with Ms. Cooney, internal communications about Ms. Cooney, any communications with third-party organizations, including the National Alliance for Eating Disorders about Ms. Cooney, contracts or agreements between TikTok and Ms. Cooney, communications or documents related to Ms. Cooney's visit on TikTok's New York City headquarters or other offices, and advertising / marketing or other promotional material related to Ms. Cooney. So they're asking for a lot here, right? Now, they're not saying outright that there is contracts between Eugenia and TikTok, but if there are any, they want to see them. They also want to see any kind of communications or documentation about her visit to their New York offices. So what happened? Why was she there? Who organized it? Did they invite her? Did she ask to go? Was there any kind of like agreement here, or what was going on there? Anything to do with that. If they have any advertising or marketing materials related to her, they want to see that. They want to see any kind of communications they have with her or about her, either internally or externally. And the fact that they're naming organizations, including the National Alliance for Eating Disorders, is kind of telling of what they might know. They're also asking for new documents and communications discussing user concerns related to Cooney, so like people reporting her, including user feedback or complaints about Ms. Cooney's relationship to the TikTok platform, user feedback or complaints about Ms. Cooney's health, internal communications, analysis, investigations, and decisions related to those complaints, communication analysis and investigations that went into the decision to block users from searching Ms. Cooney's profile and instead showing a message directing users to the National Alliance for Eating Disorders, and communications, analysis, and investigations that went into the decision to reverse the block on users searching for Ms. Cooney's profile. Now, this is extremely telling, right? Because let's just break down what they said. They're saying that at some point, you were able to search for Eugenia Cooney on TikTok, but you couldn't find her account if you searched that. If you've ever searched something you're not supposed to on TikTok or any social media site, you know what this looks like. You try and search something, a little thing pops up and says, "Do you need help?" I got this for searching something stupid. I know what it was that I searched. This was so dumb. I love whales. I love sea creatures and whales, and I love giant, big sea creatures. So I wanted to search blue whales because I wanted to see if there was any videos of people who had somehow filmed a blue whale and put it on TikTok, like professionals or like, marine biologists. Me not remembering that at some point blue whale was a horrible social media challenge where I think people got hurt or died or something. So I went and searched blue whale on TikTok and got confronted with, "Do you need help? There's help out there." And I was like, what? I just wanted to look at whales. What is happening? And then I remembered. So yeah, stuff like that comes up. So at some point, when you searched Eugenia Cooney on TikTok, nothing came up except for this ED helpline. Which would, I guess what they're trying to argue is imply that TikTok decided that Eugenia Cooney and her content and content related to her were harmful to users. However, they then reversed that block. So they want to know why that block was reversed. What happened to lead to that decision? Because if they originally found, and this is what they're trying to argue, not what I'm saying, because I'm a neutral third party, don't sue me ever, okay? I have no claim in this game. What they're trying to argue is if they knew she was harmful and had to block people searching for her, why did they reverse that block? And is that then willfully harming users, particularly young users? And then we move on to their argument for this. The supplemental discovery plaintiffs seek about Ms. Cooney is relevant to TikTok's knowledge of the mental harms caused by its platform and fall under plaintiffs' existing RFPs. As such, TikTok bears an ongoing duty to supplement its discovery responses after learning they are incomplete or incorrect, and if the additional corrective information has not otherwise been made known to the other parties during the discovery process or in writing. So all they're saying is, even though the discovery phase is over, there is a legal basis that if stuff is incomplete, they can request new documents. These targeted requests fall under plaintiffs' requests for production, requests that TikTok produced over 300 documents in response to involving Ms. Cooney. These RFPs include request number 169, warnings of any risk to children's safety. Request number 175, analysis of safety of child users. Request number 176, documents concerning adverse impact on TikTok on children's safety. Request number 178, communications about investigations, lawsuits, and inquiries about children's safety. Request number 179, documents about crisis management and communication. Request number 185, communications with employees about how to discuss adverse effects on user safety. Request number 187, user reports about adverse effect on children's safety. And request number 189, documents concerning policies for handling third-party complaints about children using TikTok. Defendants claim plaintiffs lack good cause or diligence. Defendants being TikTok, plaintiffs being the ones asking for these documents. Just as a reminder in case you're losing track of what's happening here. Not so. Plaintiffs requested these materials on May 29th, the same day plaintiffs learned of Ms. Cooney's collapse and visit to TikTok. TikTok did not respond for over a month. Plaintiffs then sent another letter on July 8th, waiting until July 21 for a response. Plaintiffs requested an H2 the same day and renewed the request on July 23rd. As such, defendants' refusal to discuss this issue has resulted in this delay. And then they just go on to detail that these requests are reasonable and relevant and that they need the documents and they're not just wasting time. Then we move on to the defendant's position, so TikTok's arguments against this. And they really don't like this. So, defendant's position. The court should enforce the fact discovery deadline and deny plaintiff's ultimate request for new discovery. Nearly 2 months after the close of fact discovery, plaintiffs made entirely new and untimely discovery demands of the TikTok defendants, insisting they produce all documents responsive to several new, sweeping categories of information concerning Ms. Cooney, a 31-year-old content creator that recently appeared in the news. Do you want to say what she appeared in the news for? This is so vague. Then we know what they're talking about. They're talking about the episode that they're referring to as the collapse, but I guess they don't want to say that. Then during this letter briefing, plaintiffs demanded for the first time that the TikTok defendants again produce for deposition employee redacted, and further claimed they are entitled to depose Ms. Cooney, a non-party to this litigation. So they're saying, they want to question Eugenia. She's not involved in this lawsuit. She is just a third party. This is not cool. Let's not do this. Fact discovery must end. Plaintiffs were aware of Ms. Cooney long before the fact discovery period closed and concede that they have already received detailed documents and deposition discovery regarding Ms. Cooney. In addition to information concerning other content creators, they explicitly identified in prior document requests. To the extent they believed they needed more about Ms. Cooney, they had ample opportunity during fact discovery. Their requests are untimely. Their motion is untimely. And for numerous other reasons explained herein, plaintiffs have not come close to meeting their burden of demonstrating the good cause and reasonable diligence necessary for this belated discovery. So they're just saying, the time for discovery has ended. They already got documents. They said they already got documents. We don't want to give them any more documents. Now, my unlawyer opinion on this, as a lay person, right, just looking at this, I would kind of argue, well, their argument is that they got new information, so they want more documents. And I don't really see how that is unreasonable of a request. They're going to argue why it's unreasonable, but, I don't agree. So here's our first argument. Plaintiffs failed to demonstrate good cause to reopen fact discovery. Fact discovery closed on April 4th, 2025, and plaintiffs have not demonstrated the good cause or diligence in discovery for new productions and depositions 4 months after the close of discovery and 3 months before trial. So they're saying they don't have a good enough reason to do this. The time is over. The time is over. No more. Moreover, motions to compel discovery filed after the close of discovery are untimely. Plaintiffs concede they already received detailed documents and deposition discovery regarding Ms. Cooney and have likely been aware of her presence on the TikTok platform and others since the initiation of this litigation. At minimum, plaintiffs were undisputedly aware of her by February 2025 when they questioned witnesses about her at deposition. So they're saying, You already questioned our witness about her. You knew she existed. You could have asked for more documents then. However, I would like to state again, in my own humble opinion, that their argument is that they didn't know she was going to collapse, because that hadn't happened yet, collapse. And they didn't know that she had visited their New York offices, and they want that information as well. Yet, plaintiffs waited until almost 2 months after fact discovery closed to seek documents and communications about her. Indeed, Ms. Cooney has visited the TikTok offices as part of similar creator events, including in 2024. But plaintiffs did not specifically request those materials then. Yeah, but they're talking about like older ones. They want the stuff related to her newest visit. Just saying. Worse, plaintiffs asked the court to compel the TikTok defendants to produce, again, documents concerning events from over a year ago that the TikTok defendant have already produced in these cases. Accordingly, plaintiffs already had ample opportunity to obtain the information by discovery in the action. Their next argument, plaintiffs' belated requests are not mere requests to supplement prior discovery. So they're saying that these are completely new requests and are not related to supplementing old stuff. Therefore, they shouldn't be allowed to ask for them. Knowing they are constrained by the fact discovery deadline, plaintiffs strain to argue that these new requests are somehow encompassed within prior ones, such that the TikTok defendants must supplement discovery. This is just a premise to obtain additional evidence out of time, given plaintiffs' lack of diligence. They are not holding back. Indeed, in the multiple letters between the parties on this issue, as well as during the last conferral with lead counsel, plaintiffs declined to identify any prior requests to which the now sought documents and communications would be responsive. This is emblematic of plaintiffs' refusal to meet and confer on this topic in a meaningful manner. Now, in this letter brief, plaintiffs identified for the first time the list of those requests they purport contain these requests related to Ms. Cooney. But none of these requests comprise the broad new discovery that plaintiffs seek related to Ms. Cooney. In fact, the TikTok defendants conferred with plaintiffs on each of these requests last year and reached agreements on narrowed scope, including limited productions to documents identified in an agreed upon custodian's file collected pursuant to negotiated search terms. Long way of saying they already got documents. They're trying to say these new documents are supplemental, but we say that they're not, basically. Tellingly, plaintiffs failed to notify the court that they previously served different requests specifically addressing creators on the TikTok platform. The plain language of these requests expressly excludes Ms. Cooney, age 31, either because plaintiffs only sought documents related to specific creators, not including Ms. Cooney, or documents involving creators under age 18. Moreover, the mere fact that certain of the over 2.2 million documents that the TikTok defendants have produced in this litigation refer to Ms. Cooney does not give rise to some duty to supplement that does not otherwise exist or confer the right to belatedly demand new searches and document collections, nor do plaintiffs cite any support to suggest that it does. 2.2 million documents. 2.2 million. Next argument. Plaintiffs' requests are neither relevant nor proportional to the needs of the case. They say the events the plaintiffs claim purportedly triggered these requests, speculation about Ms. Cooney's health following May 23rd, 2025 live stream, the one with the health concerns, and an unrelated visit to TikTok's Inc.'s office where Ms. Cooney was invited along with 500 other creators, so now we know she was invited, but not on her own, are not good cause for this discovery. Both occurred outside the court-ordered relevant time period ending on April 1st, 2024. Moreover, plaintiffs have not demonstrated why discovery concerning an adult creator's presence on the TikTok platform is relevant to their claims, particularly when Section 230 bars plaintiffs' claims of injury caused by exposure to third-party content. So this is saying that, they've already agreed that TikTok can't be held liable for any harm that was caused to somebody because they watched a video that wasn't made by TikTok, right? That's what I'm understanding. But what I believe is happening here is that they're trying to argue, yes, that is the case, but if you are promoting her, knowing that she is harmful on the platform, then you are therefore complicit in promoting harmful material, and it's therefore no longer just third party. That's what I'm understanding. Whether one of thousands of individual creators' content complies with TikTok's guidelines is not the proper subject of discovery in this litigation, which concerns the alleged addictive design of the platform. Such discovery into one of adult creators and her personal health struggles is representative of the type of sidetracks plaintiffs have pursued during discovery of the TikTok defendants, each time claiming they are being targeted in the tangent they are pursuing. So I kind of get what they're saying here. They're like, this is supposed to be about like the addictive part of the platform, and you were just talking about random creators. Like, this is not relevant. So I kind of understand there. Plaintiffs have not even identified a single plaintiff who has allegedly been injured by viewing Ms. Cooney's content, as if they would even be a viable cause of action. It is not. Instead, plaintiffs in poor taste have needlessly included selective images of Ms. Cooney without context to claim relevance, thereby exploiting someone they maintain has an obvious eating disorder. I gotta be honest, like they kind of clocked him with that one. Like, they're saying, like, they're not showing any actual harm. They're just saying there may be harm there. And their only information to this is to show selective images of Eugenia looking ill. Right? And that is, you kind of got him there, TikTok. You kind of got him there. Can't really deny that. However, I think, again, the argument that they're trying to make is based around that whole block, because if TikTok blocked her page and came up with a support helpline, then they deemed her harmful, but then they reversed the block. I think that's the argument anyway. During the conferral process, lead plaintiffs' counsel for TikTok Discovery previewed that they would do so in an effort to embarrass the TikTok defendants if they did not agree to all the plaintiffs' demands. The court should not reward plaintiffs' potentially harmful antics. So they said, like, we're going to embarrass you if you don't do what we want. Sometimes I wonder if my dad was right and I should have been a lawyer, because sometimes reading these things is so fun. Like, when I first started reading legal documents for YouTube videos, it was a headache. But then you get into it and you understand what you're reading and you learn, like, how this stuff actually works. And it's kind of fun. Because, like, lawyers get so bitchy with one another. It's fantastic. I love when they put in these little comments. It's great. And their final argument, plaintiff's 11-hour request for leave to take 2 out-of-time depositions should be denied outright. The issue is not even properly before the court because plaintiffs failed to raise it until this letter brief. No meet and confer has occurred and required by this court's standing order for discovery in civil cases. Worse, by plaintiffs' logic, their ability to take depositions, including a second deposition of the same company witness, the TikTok defendants objected to plaintiffs' attempt to keep the deposition open, and another of a non-party, would extend indefinitely as long as they have not used up all 240 deposition hours. Plaintiffs cannot point to any support for this position, as it is both nonsensical and impractical, given that the parties are now 3 months away from trial. Nonsensical. The TikTok defendants are instead focusing their efforts on trial preparation, as both this court and Judge Cole have instructed the parties to do. So they're just saying, like, okay, you guys want to depose Eugenia Cooney, like, you want to ask her questions, and you want to ask the employee that you already asked questions, more questions. Even though this is not the time to do that, you already had your chance, you didn't do it, and Eugenia is a third party, this is ridiculous, and we're supposed to be going to trial. Long and short of it. And you can't help but understand their argument in this part. So in summary, they're saying Eugenia was unwell on a live stream, and then the very next day she posted a video to TikTok in which she went to TikTok's offices in New York, and therefore they want new documents related to her. But TikTok are saying, no, that's unreasonable and silly. But now we also have the order resolving the dispute re plaintiff's motion to compel discovery from TikTok re third party Eugenia Cooney. So what is the judge saying here? Introduction. This MDL has been referred to the undersigned for all discovery purposes. Plaintiffs and the TikTok defendants filed a joint letter brief seeking resolution of a dispute regarding additional discovery sought by plaintiffs from TikTok regarding third-party Eugenia Cooney. Upon careful review of the briefing and submission, the court resolves the disputes as to the additional discovery sought from TikTok as set forein. The court finds the disputes suitable for resolution without oral agreement. Then they go into the legal standard. I am not reading that. I'm absolutely not reading that. And I'll tell you exactly why I'm not reading that, because the legal standard is the judge going over all relevant cases and sources and examples of why things should or shouldn't be allowed that are related to this. Do we want to read that? No, I don't think we do. Do you want to hear that? No, I don't think you do. If you do, go ahead and read it. I'm not interested. Actually, never mind. I shouldn't be a lawyer if I'm not interested in this part. That's kind of like the whole point, is the legal claims. But let's move on to discussion. The parties' fundamental dispute concerns 1. Whether TikTok should be required to produce additional documents relating to a non-party, Eugenia Cooney. And 2. Whether plaintiffs should be granted leave to take an additional deposition of a specified TikTok witness previously deposed, she was not disposed, she was deposed in February 2025. Whose name the parties have redacted for confidentiality and who, therefore, the court will refer to in this public order as the TikTok witness. And 3, whether plaintiffs should be granted leave to take the deposition of Cooney. As the parties' briefing and the public record discloses, Cooney is a TikTok influencer or creator who routinely posts on TikTok and has 2.8 million followers. Cooney is, in quotes, a TikTok creator suffering from and according to plaintiffs, her photographs and posings indicate that she is, quote, suffering from an obvious eating. During the fact discovery period, TikTok produced over 300 documents referencing Cooney, its relationship with her, and user complaints about her. TikTok's relationship with Cooney was a topic during the deposition of the TikTok witness taken in February 2025. So, they say, request for documents from TikTok re Cooney. After the close of the fact discovery, Cooney apparently fell ill during a live stream broadcast on TikTok on May 23rd, 2025. Cooney also apparently visited TikTok's offices in New York around this same date. After learning of these events, plaintiffs requested TikTok to produce supplemental documents concerning Cooney. The parties did not reach agreement on this issue, resulting in the instant letter briefing. In the instant brief, plaintiffs seek an order requiring TikTok to produce 2 broadly phased categories of documents concerning Cooney, comprising multiple subparts. We already read this. This is a direct copy and paste. It's actually a screenshot of what kind of documents they asked for. So I'm not going to read that again because we literally just read it, guys. We just read it. We know what they're asking for. Plaintiffs argue that these supplemental productions are required under Rule 26E because these requested documents are responsive to documents request numbers 169, 175, 176, 178, 179, blah, 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 blah. So they're saying that they are in some way related, right? Plaintiffs argue that these new events involving Cooney and TikTok are relevant to TikTok's knowledge of the mental health harms caused by its platform. Which is what I was saying. They're arguing that, no, this is relevant because if they know she's harmful and they're promoting her anyway, does that not then make them complicit in the harm and knowing of the harm? TikTok argues that none of these documents requests call for the documents now sought. TikTok further argues that plaintiffs and TikTok negotiated agreements to narrow the scope of these agreements last year, which included limiting production to certain agreed-upon custodians and using agreed-upon search terms. Further, TikTok argues that plaintiffs are explicitly asking for an order requiring TikTok to reproduce documents that TikTok has already produced, specifically relating to certain restrictions and changes made to Cooney's account and its accessibility. TikTok argues that plaintiffs have known of Cooney since at least the February 2025 deposition of the TikTok witness discussed above. TikTok argues that there were past creator events at TikTok's offices in 2024, similar to the event in May 2025, which Cooney attended, and plaintiffs never sought documents concerning her participation in those earlier events. Further, TikTok points out that the plaintiffs served completely different sets of document requests, which directly sought documents concerning creators on the TikTok platform, and none of those requests sought documents relating to Cooney. TikTok thus argues that the requests are now ultimately untimely and not justified by the claim that plaintiffs only recently learned of the events which gave rise to these requests. As noted, there are two events which occurred after the close of fact discovery which triggered this dispute. Cooney's May 2025 live stream, which she apparently fell ill, and her visit to TikTok's offices in May 2025 for a creator event. While these two events themselves may be within the scope of relevance for purposes of discovery, plaintiffs have not demonstrated how discovery beyond these two events requires supplementing, nor have plaintiffs shown how these two events justify the broad scope of documents requests now being proposed. So, what's being said here is that the plaintiffs, the one asking for the documents, have not explained why they need documents beyond anything to do with the live stream and her visit to the offices, because they're also asking for other stuff related to her, relating to her ban and then unban, or the banning of searching her and then unbanning that, other documents related to her and communications about her. Further, even if there was some scope of relevance beyond these two events for purposes of discovery, plaintiffs have not shown how the two broad categories of documents sought, each with at least 6 subparts, are proportional to the needs of the case. Kind of same thing, like they're not saying how it's relevant. The multiple categories of documents now sought go far beyond these two events involving Cooney. It is clear plaintiffs are seeking to reopen broad areas of discovery into TikTok's handling of not just these two events, but anything having to do with Cooney, and more generally, comprehensive inquiries into TikTok's external and internal communications, analysis, and documents regarding Cooney or complaints about her. So, saying again, this isn't really relevant. You're not supplementing information. You're now asking for a whole new set of information, even though the discovery period has ended. More tellingly, the documents requested now are not limited to time period, which facially demonstrates that 1. Plaintiffs had every opportunity to seek most of these documents before the close of fact discovery and chose not to, and 2. The requests for documents are now not adequately linked to the events in May 2025 which initiated this dispute, except for the sole subcategory which specifically seeks documents relating to her visit to TikTok. But even that request seeks documents concerning her visits to other TikTok offices without limitations as to time period. So, again, they're asking for stuff that isn't related to these two events that they're using as their argument. After taking the February 2025 deposition of the TikTok witness, plaintiffs could have sought every category of document now sought, except for the ones about her visit and the livestream. These factors demonstrate that the requests for documents now are not proportional to the needs of the case. Further, the fact that plaintiffs served document requests which are specifically directed to creators, yet omitted Cooney, is additional support for the conclusion that the requests asserted now are not proportional to the needs of the case. Plaintiffs knew about Cooney during the fact discovery period and could have decided to include her in the creator-directed document requests. If documents about Cooney were deemed by plaintiffs not to be important enough to pursue in response to requests regarding creators during fact discovery, that was a long sentence, if they didn't think it was important at the time, basically, the events in May 2025 do not materially alter the conclusion that such broadly sought documents about Cooney are proportional now, because there is no explanation as to how these events suddenly made those documents that much more important to the needs of the case now. If the documents were not important enough to pursue during fact discovery, they are not important enough to require their wholesale production now. The mere fact that plaintiffs would like to have these documents now because the recency of these events surrounding Cooney is simply not sufficient. You followed, right? They're saying, okay, you could have asked for these documents before. You're now using the two events that you're talking about, the TikTok visit and the live stream, to request these extra documents that aren't related to the TikTok visit or the live stream, but that's like not sufficient because you could have had them before and you didn't ask for them. Plaintiffs do not respond to TikTok's assertion that plaintiffs are seeking reproduction of documents which TikTok has already produced concerning Cooney regarding restrictions on her account. This factor also demonstrates that the requests, as presented now, are not proportional to the needs of the case because they are apparently duplicative and seek to pose unnecessary and undue costs and burdens on TikTok. So apparently they already have these documents, even though there's like specifically about them blocking her account and then unblocking her. Accordingly, the court finds that plaintiffs' requests for documents now, as presented, are not relevant to the extent they seek reproduction of documents already produced, because, by definition, duplicative documents do not themselves add any relevant information that is not already previously produced. So they're like, you already have this information, you don't need it again, and are not within the proper scope of proportionality for discovery. Plaintiffs have shown that, at best, there may exist a modest scope of relevance and proportionality for documents relating to the two events which gave rise to this dispute: Cooney's May 2025 live stream and her May 2025 visit to TikTok's offices. However, as discussed above, there is only a duty to supplement a discovery response under Rule 26E if the request called for the discovery now sought. Accordingly, even if the two events that occurred in May 2025 involving Cooney may be within the scope of relevance, and proportionally, the scope of document requests that require supplementation is limited to those which would fairly call for the production of documents concerning those two May 2025 events. Did you follow that? That was very wordy. Basically, like, only the two May stuff, the stuff that happened in May 2025 is relevant. I really need some water. It's a lot of reading. The court has reviewed the document requests which plaintiffs argue now call for the supplemental production of documents. The only document request which even addresses meetings in document request number 176, which seeks any meeting agendas, presentation, material, handout, background materials, or other documents concerning any actual or potential adverse impact on your platform on the safety of children, teens, and youth, users that were discussed, tested, proposed, or blah, 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 blah. Just the legal jargon they used. This document request does not seek all documents concerning any meeting, of course. Based on the party's submission, it is not known, but at least possible, that Cooney's visit to TikTok's offices in May 2025 could have included any meeting agendas or other documents concerning any actual or potential adverse impact that TikTok might have on user safety, and it appears equally unknown whether any such materials were discussed, tested, proposed, or implemented by persons working on user safety issues for TikTok. So what they're saying is, like, they had previously asked for documents from TikTok about any conversations, meetings, whatever, about their impact on the youth. And what they're saying here is that, well, it's possible that when Eugenia was there was a meeting about impacts on the youth, but like they don't know that, but it is possible. With regard to Cooney's May 2025 live stream, none of the documents requested listed by TikTok call for anything directed to a creator's live stream. Document request number 175 seeks all documents concerning any actual or proposed analysis by TikTok concerning the topics of problematic use or safety of youth users on your platform. Based on the submission of the parties, it is unknown, but at least conceivable, that TikTok may have documents concerning analysis of whether Cooney's live stream in May 2025 on TikTok was problematic or impacted youth users' safety. So basically, again, what they're saying is previously the plaintiffs had asked TikTok for documents regarding any analysis they did on whether stuff was negatively impacting users. And what they're saying now here is that it's unknown whether TikTok did any analysis into whether Eugenia's live stream where she was unwell had any impact on users, but it is possible that they have analysed whether this had a negative impact on users. So if that analysis exists, it could be relevant. Document request number 178 seeks all communications by or with TikTok concerning investigations, lawsuits, media inquiries, or government inquiries related to the safety of children, teens, and youth who use your platform. Further, document request number 185 seeks documents reflecting communications with your employees, contractors, or vendors regarding when, whether, and how they should discuss the topic of whether use of TikTok is associated with adverse effects on user safety, including problematic use. The party's briefing has cited to media coverage of Cooney falling ill during her May 2025 livestream on TikTok. There is thus a basis to conclude that TikTok received media inquiries, if not other investigations or government inquiries, related to user safety based on or stemming from Eugenia's 2025 livestream event. Similarly, there is a basis to conclude that TikTok sent communication to employees and contractors and vendors, such as public relations firm, on when, whether, or how to discuss whether Cooney's May 2025 livestream was problematic and whether that use was associated with any adverse effects on user safety. So what's being said here is it's quite likely, and there is evidence to show that potentially TikTok did have to have some discussions around whether Eugenia's stream was problematic, and they had to send out PR comments and stuff like that about this. So there is communications about that, and that potentially falls under stuff that was previously asked for. Are we all following? I don't know if this is too wordy, but I think you get what's going on here. Tell me in the comments, are you following or are you lost? Finally, document request number 187 seeks all documents received by TikTok regarding any adverse effect on the safety of a child, teen, or youth user of TikTok and TikTok's response. Based on the submission of the parties, it is unknown, but at least conceivable, that TikTok may have received user complaints in response to Cooney's TikTok live stream in May 2025 with regards to an adverse effect on user safety. So, again, to summarize that part, probably when Eugenia was ill on the live stream, people made reports about that to YouTube. Users went and reported her account and might have cited adverse effects, that this was harmful. And if that was the case, then it would be relevant to the case. And as I already said, people are reporting her account all the time, so I would be shocked if nobody reported her during this live stream. It would be the most shocking thing of all time. God himself could come down and declare that every day is now Sunday. What am I talking about? Anyway, he could do that, and that would be less shocking to me than this. In light of the above analysis of the proper scope of relevance and proportionality, and further, in light of the analysis of which, if any, of the identified document requests seek documents relating to the two events in May 2025 involving Cooney, the court concludes as follows. So, this is what the court is saying now has to happen, right? This has to happen. Here's the big conclusion of all of this. TikTok is ordered to perform a reasonable search for and make inquiry for documents from a reasonable number of custodians who either were directly involved in Cooney's visit to TikTok's New York offices in May 2025 or were directly involved in any user safety, media inquiry, or user complaint issue concerning Eugenia's 2025 live stream event. The court orders TikTok to include among those custodians the TikTok witness who was deposed in February 2025. So they're saying, yes, anything that is related to these two events, to the live stream where she was unwell, or to her visit to the New York offices, you must look for the documents related to that, and you must produce those documents. But anything that's not related to that doesn't need to be produced. So anything about her username being banned from the search terms, anything like that, not relevant because it doesn't relate to these two events. So it's only stuff relating to these events, but still that's really huge. By no later than November 10th, 2025, so really soon, TikTok shall serve supplemental responses to document request number whatever, and in such responses shall include whether, after a good faith, reasonable inquiry of those custodians called for by this order, any non-privileged responsive documents exist which relate to Cooney's May 2025 visit to TikTok's New York offices or relate to her livestream event. When making inquiry of custodians and searching for documents in compliance with this order, TikTok shall specifically include but not be limited to, inquiry about and searching for the types of documents discussed by the court above, which may be conceivably, possibly, or potentially exist. So that's just saying, like, you not only have to look for these documents, you have to produce them before the 10th of November, which again, really, really soon, so they don't have much time to do this. The parties are ordered to coordinate and collaborate on filing a 2-page weekly joint status report on the status of the supplemental response to these listed documents requests and the status of any documents produced starting on November 17, 2025, and continuing on a weekly basis until any supplemental document production is completed. So, like, every week, you gotta tell me what you got, what you received. Both of you. And then we move on to the conclusion about the deposition of Eugenia. So, like, the plaintiffs asking to question Eugenia. In addition to the documents sought, plaintiffs request that the court issue an order granting plaintiffs leave to take a further deposition of a specific TikTok witness, not Eugenia, and a deposition of Cooney herself. TikTok opposes this request because it is untimely and because there was no meet and confer on this issue. As noted above, plaintiff's motion is based on the argument that Rule 26E requires supplementing the discovery responses previously served by TikTok. But, as discussed above, the amendments to Rule 26E clarify that the obligation to supplement responses to formal discovery requests applies to... Oh, sorry guys, I've been reading for a really long time. Applies to interrogatories, requests for production, and requests for admissions, but not ordinarily deposition testimony. Blah, blah, blah. Thus, there is no legal basis to request a supplementing deposition. Accordingly, the court denies plaintiff's request to order a further deposition of TikTok or of TikTok witness or a deposition of Cooney. With regard to Cooney, the court notes that she is a third party and has not appeared in this action. Indeed, no leave to serve a subpoena was requested, and she may be wholly unaware that her deposition was even sought by plaintiffs. As noted above, the court is particularly aware of its obligation to enforce the duty imposed on a party or attorney, issuing a subpoena to take reasonable steps to avoid imposing undue burden or expense on a person subjected to the subpoena. Okay, so basically all they're saying here is, like, Eugenia is a third person. She is not related to this lawsuit. She's not actually actively involved in this lawsuit, even though she's being named in certain things. This is between the plaintiffs and TikTok and other social media sites. So, like, no, you cannot depose her. You cannot ask her questions. That's gonna, like, cause a burden on her, and she might even not know that she was named here. I have a feeling she probably doesn't know that she was named here, but that is just a hunch. Like, there is nothing to actually... There's no evidence to that. That's just what I think. So, the conclusion. For all the reasons discussed here, the court grants in part the motion to compel TikTok to serve supplemental responses to specific document requests and produce non-privileged responsive documents, if any exist, as discussed above. Further, the court denies plaintiff's request for leave to take a further deposition of the TikTok witness and denies plaintiff's request for leave to take Cooney's deposition. Blah, blah, blah. It is so ordered on October 20th, 2025. So only 2 days ago, they ordered that, yes, you need to give us extra documents, not all the documents, and no, you cannot ask Eugenia any questions. Why would that be relevant, basically? As for what this all means, though, I do find it a little bit concerning because I understand the argument of, well, if TikTok believe Eugenia Cooney to be harmful and they're still promoting her, then they're the ones doing the harm. TikTok are the ones doing the harm because they're promoting somebody that they believe to be harmful to their users. And that's all well and good, and I think that's a point that could be made, especially with the right documentation. However, the idea that they want so much extensive information on Eugenia, on their analysis of one individual user, of their communications about and with one individual user, it's a little bit too far in my opinion. Obviously all of this is my opinion. And the fact that they wanted to depose her, to ask her questions and bring her into this case that isn't about her, it's about the harm of social media platforms, is also concerning. Because if all of this were to have happened, it could set a precedent where individual creators could be held accountable for the standards that are meant to be put on the platform themselves. Like, if the platform is the one promoting harmful materials, it's the platform's fault at the end of the day, in my opinion. But if they had managed to get all of this stuff from Eugenia and all of like the information about her and whatever communications with or about her, as well as being able to depose her, it could have meant that going forward, more creators were going to be brought into stuff like this. More creators were going to have to take the burden for what the platforms themselves are failing to do or are actively doing, when it's supposed to be the platform that's held accountable, not the creator. And it also kind of, in my head as I was reading this, because obviously I live in Europe, we got the whole GDPR thing. I was like, surely all of this it's delving into releasing private information about a user at the end of the day, rather than about the platform itself. Like, that again sets another dangerous precedent of like, any user, could their privacy just be betrayed because it could potentially be relevant to some legal case. And I'm glad that the court ruled the way they did, to be honest. I do think there's something to be said for the blocking and unblocking of Eugenia's account. Because that does potentially show that if they blocked her, they knew she was harmful, but then they unblocked her, so why did they do that? But the court seems to think that the plaintiffs already have those documents, so that could still be relevant. And that is relevant because that's about TikTok's actions, but I'm just glad that the judge ruled that it was only going to be documents relating to Eugenia that are relevant to what they're investigating about TikTok. Because if they had just said, sure, yeah, any document you want about Eugenia you can have, just take it, there you go. Again, that's delving into privacy concerns. It's setting a precedent for future lawsuits where individual users or creators could be brought up in stuff that isn't really to do with them. So I think it was the right call, and I don't think deposing her would have made sense either. For one, like, what are you going to achieve from that? She is, as the court ruled, a third party. She's not the one being sued, right? She's not directly involved with this lawsuit. She is just being used, essentially, the way I'm seeing this and the way it's being framed is she's essentially being used as a case study into whether TikTok is actively or willfully or negligently harming its users, particularly young users. She's supposed to be a case study. And you don't depose the case study. That doesn't really make sense, at least in my opinion, anyway. I'm going to keep saying my opinion because I don't want to get sued, guys, okay? Like, that is so not the vibe for the following year, okay? No lawsuits for me, thank you. It just wouldn't have made sense to me. And then also, it's like, why? What are you going to gain from that? Anything you're going to gain is going to come from the documents, and you need to have a good reason for wanting those documents. You can't just have anything about any user you want. This is not me like saying Eugenia's like absolutely fine, whatever. Clearly that's not the case, and clearly there is an argument to be made, but you can't just have all the information about her. It's not right. I mean, you can disagree with me, right? And obviously, if you agree, if you disagree, let me know in the comments what you think about it. But this is just what I think. I think it kind of ruled the right way. I don't know if maybe too much was being asked for, but I think the judge did a good call with, like, okay, where it's relevant to user reports about whether her live stream where she was ill was damaging, or reports about communications they made because of the live stream, any PR tactics they had because of the live stream. That's all relevant to the question that's actually the main question of this lawsuit. Because remember, the main question of this lawsuit is whether TikTok and other social media platforms are harmful for the mental health of children. That is what they're looking into. And they can't really stray from that. If they want to do something else, they can, but that is what they're looking into. So it makes sense. And obviously about the TikTok visit, where it might be relevant, I suppose. So there you go. But as of now, like, obviously Eugenia herself hasn't commented on this. Maybe the judge is right. Maybe she hadn't a clue. I think she probably knows. But a lot of people are now speculating that this is the reason that she's not been online. That because of this, she was either banned from posting, demonetized on TikTok, or there were some communications between her and TikTok where they asked her not to post for a while. The reason people are suggesting this is because if she keeps posting, it could just cause more issues. Something else could happen. That could be brought up as more documents they need to provide, more drawing this whole thing out when they're supposed to be going to trial soon, and I'm sure TikTok probably want it to be over. So, like, this is probably potentially, not probably, I can't say probably, because that would be defamatory, maybe. But this is potentially why she's not been online. Something to do with TikTok's involvement with her account, whether they actively told her, which may be unlikely, or they demonetized her account so she can't make any money off it, or they banned her from posting or streaming, because she has still been online, by the way. People have seen her in Jeffree Star's chat on his lives. So she is online, she's just not posting any content and she's not going live herself. So it could be something like that. You never know. Obviously, I do want to see where this goes, and they said that they have to provide these documents by the 10th of November. Now, I don't know if these are going to be released to the public, but if something is released, I'm going to look into it and see what's going on with this. I'll keep an eye on this, where it's going. But in the meantime, could you guys give me just a minute, please? Please, a minute of your time. It's not for a sponsor. I promise it's not for a sponsor. I just have some really, really exciting news and I really want to share it because I got something really cool this morning. You ready? You ready? Wait, don't look. Drum roll that I'm so not going to edit in. I'm so not editing in a drum roll because I want to get this video out today. But it's my book. I got the proper, not proof copies of my book, because before I only had the proof copy, and now I finally got the copies of my book. My debut, my very, very, very first novel that I wrote with my tippy-tappy typing. I wrote this. And it's coming out on November 16th. And I'm so excited. Bound by Blood and Sea, if you haven't heard me yapping about it up until now. It is a dark fantasy novel with gay mermaids and Irish mythology and fae and court politics and drowned gods. And I'm so excited. It's the first in the series. It's called the Drowned Gods series. And yeah. Sorry, I'm so excited about this. I got a load of copies for me, for like friends and family, and for the PR boxes that I'm sending to book talkers and stuff. So I'm waiting to get the rest of them for signing and sending to people. But if you would like to pre-order this book, you can pre-order the paperback on my website. You can pre-order the ebook on Amazon or wherever you get your ebooks from. And I'm just so excited. Thank you so much. I already have 900 pre-orders, which is absolutely mind-blowing. It's like, so if you don't know, like, apparently most books don't reach 500 sales in their lifetime. And I have 900 pre-orders already. And the more pre-orders I get, the more it's going to be pushed to people on like Amazon and stuff, so more people will see it and more people will have a chance to read it, and I'm just so beyond excited. So please, if you would like to read it, please consider pre-ordering it, or else if you want to wait till the release date and you want to buy it on the day, because that's also really helpful if you buy it on the day that it releases. It's out on November 16th. In my video about Audra Winter, I read an excerpt for you guys, but I'm just going to read like the back cover because that's not online anywhere and I haven't read it. That's a little bit shorter than a whole extract from the book, and obviously I haven't read this out loud. It's different from the like Amazon and Goodreads and stuff thing, which, speaking of Goodreads, the reviews have started coming in, just the early reviews, and people are really positive about it and people like it. So I think maybe I didn't write a total piece of shit which would be great if I hadn't spent years of my life writing a total piece of shit. Anyway, the back cover says, "Blood in the water lies on land. Born into the Marrow, a race of shape-shifting merfolk, Tern Branlock has always known her place. A devoted daughter, a future leader, and a loyal member of the Forbidden Order of the Drowned. As tensions rise, she's forced into an arranged marriage with Caleb Morven, an arrogant Fey lord and heir to a house on the brink of ruin. But most dangerous of all is Etain, Caelan's sworn guard, a woman whose sharp gaze and unexpected pull threaten to unravel Turn's careful control. To the outside world, Tern is a bride. To the Order, she is a weapon sent to bring their enemies to heel. And the deeper she treads into this world, the harder it becomes to tell loyalty from betrayal." So there you go. That's the back cover. You want to read it? Want to read my Gay Mermaid book? You can. You absolutely can. So, thank you. And I'm so happy with how the cover turned out. I'm like so excited about this. Thank you guys for like listening to me when I yap about this. Like, you have no idea how much it means to me, how much support you guys have given me on this. This has taken over so much of my life. Obviously, this has taken years, but book 2 won't take years because I've spent years building this book and it's my first book, but book 2 is already kind of written. Already kind of wrote it, guys. So, like, don't worry. It won't be a billion years till you get that. So, read the book, please. If you plan on reading it, add it to your list on Goodreads. I'm kind of only just learning how Goodreads works, so excuse me. But yes, this is my book. And I'm like, I'm not somebody who feels excitement. It's kind of an emotion I've been missing in my life. I know that sounds like I'm being dramatic, but no, I really like things like a sense of achievement and excitement. I just don't have them. I don't know if it's an ADHD thing or something, but this is like, I'm genuinely excited. I'm genuinely so excited about this. And that is a really cool feeling. And it's so nice to hear people really enjoying the book already, even though people were sent like the early versions, which they were made aware may have some typos. And I found some typos and I fixed them. So there should be no typos. You have no idea how many rounds of revisions and proofreads this went through. So many proofreads. So yes, check it out. I'll stop yapping now, but thank you so much. If you want to hear more about this, go on my website. Okay. Anyway, thank you so much for watching. Please let me know in the comments what you think about all of this. If you don't leave me a comment about that, then leave me a comment that just says book, for obvious reasons. Like, comment, share, follow me on social media. I am VangelinaSkov everywhere. And most importantly of all my angels and baby dolls, please remember to subscribe. Really helps me a lot if you do that. It really does, honestly. I know people don't like to subscribe to channels anymore, but just do. It helps. Turn on notifications, whatever you want to do. And I think that's everything. You can check out my Patreon too. Have an absolutely wonderful rest of your day. By the way, I forgot to say my website is evaalexandra.com. EVAALEKSANDRA.com. That's the website. And I will see you in the next one. Bye.